Hello and welcome to GRA TV, your trusted source for tax information. My name is Assistant Revenue Officer Victoria Kukua Williams of the Customs Division. Today is going to be an exciting session because we have two customs ladies who are also seasoned lawyers of the legal affairs of GRA here with us. We have Madam Emma Kukua Otoo and Madam Doris Agbetsise here with us. You are welcome to today's session.
Thank you.
Great. Today's session is going to be on customs offences and penalties. So first of all, I would like to know, what is customs about? And what are the various legal frameworks that govern customs operations?
Wow, that's a big question. But we would like to simplify it and say that GRA came into being in 2009, and that setup put three institutions together. So Internal Revenue Service, VAT Service, Customs Excise, and Preventive Service was put together to make one unit called Ghana Revenue Authority. In 2016, all these divisions that were put together were given laws. So Customs Division is a division of the Ghana Revenue Authority. The legal provision that was given to it in 2016 is the Customs Act called the Act 891, with the regulation by name Regulation 2248. So simply put, that is the legal provision protecting Ghana Revenue Authority Customs Division, to be specific.
Thank you so much, Madam Emma.
You're welcome.
Now to Madam Doris. Narrowing down on today's topic, customs offences and penalties, can you give us a brief overview of that?
As already submitted by Madam Kukua, Customs became a division of the Ghana Revenue Authority per an Act of Parliament, as she has mentioned. This is governed, the division is governed by the law and the LI that she has mentioned. There are other laws that we work with, like the Revenue Administration Act, because of GRA. And to buttress her assertion, the GRA Act, specifically Section 17, mentions how divisions of GRA will be made. So with all these legal frameworks in them, because they are acts of parliament, there are offences mentioned or provided for. We talk about offences because they have their prescribed punishment. Even if there is a violation, which is an offense, and there is no prescribed punishment, we wouldn't consider it as an offense. So strictly, the offenses are violations of the Customs Act and its related or relevant other provisions or laws with prescribed punishment to go with it. And throughout the Customs Act, you will find these violations based on the particular procedure that any taxpayer will put his or her consignment to. If there's anything.
Wow, thank you for that, Madam Doris. Now to what you just mentioned, who can commit a customs offence?
Okay, for customs offense, I mean, we don't say that a particular person can commit customs offense. Any person who decides to import goods and vehicles or export goods and vehicles can commit an offense, whether intentional or not intentional. So far as you have decided to import goods or vehicle, there are processes that you have to undertake. And anything contrary to those processes stated in 891
Okay.
then is an offense. And penalties or sanctions are within the Act.
Okay. Thank you. So, Madam Doris, can you give us some examples of customs offenses?
To mention some examples, I'll look at the stakeholders involved in customs procedures. We have the taxpayer, who could be an importer or exporter. We also have the customs house agent, who acts on their behalf legally. We have the officers of the customs division also. And we have persons who may have some interest. They may not be any of these three categories that I've already mentioned. They may have some interest in a way or the other who could commit offenses. So talk about the importer or exporter who is a taxpayer. If you misdescribe your goods, declaring your intention to us by using the customs declaration, which is the statutory form that anybody who wants to put any of these, his or her consignments under any procedure must fill. You need to fill that form. Filling the form, you are declaring your intention to us. And offenses are not offenses when intentions are not expressed. So we consider the intention. So when you fill the form, you fill the form as required and state how you want it to be treated. So you can misdescribe your goods. You can even state a wrong country of origin just to cut down on your tax obligations. If, for instance, if you state a wrong country of origin, it may affect your freight, which will eventually affect the duty element that you owe or duty obligations that you have to fulfill. You can also under-declare the goods. You can over-declare the goods, and among others. Yes.
You mentioned over-declaration. Why would someone over-declare and pay more to customs? When does this happen? Do you get it a lot of times? And why is it an offense if I'm paying more to customs? I thought customs is interested in revenue.
It may not necessarily result in you paying more.
Okay.
There is no one who will want to overpay. And even when you overpay, we need to, GRA will have to refund because eventually they come for a refund.
Yeah.
So unless the intention is to cheat the state, per what quantum of duty you should pay, anyone who over-declare will do that just because they want to pay less.
Great. So that's the end result. Okay. So you mentioned the customs declaration form and you mentioned intentions. What happens if I provide falsified information on my customs declaration as an importer? What happens to me?
Well, as you described as falsified,
Yes.
so anything, even generally, false documents are not acceptable.
Okay.
So if you decide to put in false information in your declaration, then on the basis of that, we can give you sanctions.
Wow. Yeah.
Yes, because the declaration is your intention.
Yes.
So if your intention is false, then all the processes are false.
Interesting.
Yes. So give us your intention, which is clear and not falsified. And the intention against the falsification might not be your fault. Because sometimes a person might say, I'm importing 10 containers of maybe tomatoes and state that intention on the declaration, then by the time the goods come in, the exporter has bought you 5. Your intention was not false, but the after results was false because when the containers got here, it was 5.
Okay.
There are procedures in order that you will correct that information so far as it's not going to affect your taxes.
I think you've rolled into my next question.
Right.
You mentioned you can correct your intention. So if my original intention changes, are there protocols to amend those intentions, those changed intentions? Is it an offense for me to try to change the intention?
Amendment is not a crime, so long as human errors exist. So we have room for amendment of declarations. That's why when you take declarations, you may have different versions of them. It starts with version 0. When it's amended, you go to version 1, version 2, and it follows. So attempting to amend your declaration is not an offense. We may even call your attention. Yours is to furnish us with evidence that you really need to amend. Some of these amendments will have to go through processes. The shipping line comes in, the exporter comes in. If all these go well, your amendment will be validated and you can clear whatever is either short-landed because all didn't come, or if there's oversupply and want to pay. So amendment is not an offense.
Wow, that was so good. Thank you, Madam Doris. So in your earlier submission, you mentioned that some of the examples of customs offenses are misdescriptions, providing falsified documentation, undervaluation, overvaluation. So my question is, what are the consequences of non-payment of duties or underpayment of duties, or even failing to submit the right documentation for clearing?
Well, all the examples have consequences, and the general sanctions are penalties that are imposed on the taxes that you are required to pay. So if you short pay the taxes, Commissioner General has a range in which these sanctions will be given you. These are penalties. So you pay the principal plus penalty, ranging from 50 to 300% penalty, depending on the gravity of the offense. Because some of the descriptions might not be the fault, that's, as I already said, that it might not be the fault of the taxpayer. It might come from the country of origin. Maybe he decided to bring it from India. India also imported it from another place, and all those complexities with importation. So if your intentions are clear and it is not falsified, then Commissioner General, even in terms of giving you sanctions on the penalties, you might, either reduce it or increase it, ranging between 50 to 300% penalty on the taxes that you are required to pay.
Wow, that is huge.
That's really huge.
Then I'm sure this is more punitive.
Yes.
And they also serve as deterrents for those who...
Required to. Even though we know that a lot of people still come back and then sanctioned and they continue paying. But it is a deterrence within the law for you to, if you are required to pay 100 cedis and then there's 300% penalties, it will have effect on your business.
Wow. Yes. Okay. Thank you so much.
You're welcome.
Madam Doris and Madam Kukua. Okay, so my next question is, anytime we hear about customs, we hear smuggling. Smuggling is a very huge term in customs. So I would like to know, what are the penalties for smuggling? And if you can give us a brief overview of what smuggling is.
Smuggling is not really defined in the Customs Act. But though in the provisions, some of the sections you see smuggling, but it's not defined. But when you go through the act, you see uncustomed goods. These are goods that are not entered. When we talk about entry, you've gone through the procedures, the processes, not procedure, the processes that lead to payment of the customs duties and taxes. Smuggling is someone attempting to clear or take goods, okay, that are imported from another country into Ghana, or goods being taken from Ghana to another country without going through the right processes and procedures, in particular with the aim of avoiding payment of the statutory duties and taxes.
Okay.
You will notice in the act that these goods could also be either restricted or prohibited. And when you strictly look at Section 121, there are provisions there for offenses, okay, or violations that don't have their penalties prescribed. Others have them prescribed, so you will see it, but there are some that don't have them prescribed.
Okay.
Strictly so, to add to what Madam Kukua said, it is not just payment of fines. Summary conviction in court. That is customs or the legal department of GRA prosecuting the offender in court and proving to the court that truly you have committed this offense. Based on the gravity of the offense, you can be made to pay fines. And these fines are in penalty units. A penalty unit is 12 cedis as of now. It's not been reviewed. So some 50 penalty units, some 2,500, some 3,000, depending on the particular offense. You can also be imprisoned.
Interesting.
Yeah.
And imprisonment ranges from between, I think, 2 years to 20 years, depending on the offense. So it is not just, oh, let me do it, I have money, I can pay penalty when it's detected and whatever.
It doesn't stay there.
You can be prosecuted. Anybody, any person that commits an offense.
So you mean someone can be jailed
Oh, yes.
for committing a customs offense?
But if it will interest you, Section 121, subsection 1, strictly, specifically, states it on summary conviction, this penalty units, or a term of imprisonment. Yes.
Now to a very dicey topic, bribe. It's a topic that we don't really want to talk about, but we can't talk about customs offenses without mentioning bribe.
Yeah.
So can I be prosecuted for attempting to bribe a customs officer? And the other way, if a customs officer takes bribe, do the law make provision for punishing them, or it only ends with the importer or the external stakeholders?
Yeah. So generally, anybody who takes bribe is required to be punished.
I see.
I mean, if you go even outside customs law, you cannot take bribe without being punished. So within our act, there are consequences for you taking bribe. So I would take that. When a taxpayer even tries to give you bribe, it is not allowed. In whichever amount, it is not allowed. Bribes are not allowed. Bribe is just to influence you to do something wrong.
Okay.
So in our act, there are provisions within it that you cannot you cannot take a bribe. Whoever is giving a bribe and the person who is also taking a bribe are all guilty. And there are sanctions within the law, which, when you go contrary to it, either in prison or as a customs officer, when you take bribe, there are legal procedures, there's a disciplinary procedures within the CBA that you will face. In addition, if it is so grievous, you've been prosecuted.
Wow.
Yes. So the taker and the giver are all guilty under 891.
Okay. Thank you so much.
I'd
Okay.
like to add something to it.
Respectfully, if I can add something. Bribery affects the quantum of revenue that the state needs to prosecute all the developmental programs. So for someone to attempt to bribe you, or for an officer to demand for a bribe, having detected something untoward towards the law, and therefore demanding, give me this, let me do this for you, in order to do what will affect the amount of revenue. It's something that the state, we all hear about corruption here, corruption there. So anybody who asks for a bribe, well, my sister spoke about the giver trying to influence. The officer can also influence a taxpayer to give bribes. Yes, that one you are demanding for it. And it will be very good we all note this, such that the taxpayer should also be on the alert to help the state in order for us to get whatever revenue, the targets that we are given, in order to help the state execute all the developmental programs that we need as a nation. So the law frowns on it, and it's specifically provided for.
Okay. Thank you so much for this insightful session. But I would like to ask if you have any final remarks to tell our viewers, anything that you would want to add to this whole discussion on customs offences and penalties.
In summary, from my side, that customs offences are within the 891 and within the regulation. If you want to import, please ask for information before you import.
Great.
Don't decide to import and then the goods are here before you are asking what you are required to do.
Say ignorance of the law is not.
It's not an excuse at all.
Okay.
And Customs Act is strict.
Just.
It's like Act 30, which is the Criminal Offences Act. It's strict. So anything that you do that is contrary to what you are supposed to do in terms of importation of goods and vehicles under Customs Act, you should seek the right information before you even intend to import. That's all that I'll add.
Thank you, Madam Emma.
You're
now
welcome.
to Madam Doris.
Because generally, the taxpayer, the importer, does what we call self-assessment. You know what you want to import. You know the description, the volume. You know the value. So we have room for you to present to us your assessment. And just as my sister said, because it's strict compliance, you can't do otherwise. I wish to state that the 891, the Act 891, which is the Customs Act, gets amended many times, especially when there is a budget that's read and the government decides to vary any of the rates or procedures. So any importer, taxpayer, customs house agent, the ordinary citizen, the officers should be interested in all those amendments and educate him or herself, yes. Otherwise, walk into our offices and make the inquiries so that you can help the nation execute all its developmental programs. Thank you.
Thank you. Thank you. All too soon, we've come to the end of this insightful section. Once again, I want to thank Chief Revenue Officer Otoo and Chief Revenue Officer Doris Agbetsise of the Legal Affairs Department. Thank you for being with us. And to our viewers, thank you for tuning in. You know, GRA cannot exist without you. If you want more information on customs offences and penalties, visit our website gra.gov.gh, and we'll be very happy if you follow us on all our social media platforms. GRA, Ghana First.